do we want to go to Chauvin because there has been some big developments?
Sure. So
okay,
sorry.
No, I was going to say go for it because we're in. I don't know where we're into jury selection if we finished it, but what was the big judgment that came out? I think on Friday or yesterday? Not yesterday.
It was the evidentiary ruling. So the bad news for Chauvin is the jury is probably the most diverse jury in the history of Minneapolis. There's 13 of the 14 have been selected. They'll probably pick the 14th on Monday or Tuesday. And then a week from Monday, the trial will start. The motion to transfer the case was denied. The motion to continue the case was denied. The jury group, two of the jurors who had already been selected said that the nature of the $27 million payout by the city led them to believe they could no longer be fair and impartial. So they had to be removed and substituted in. The jury, like if a jury a typical Minneapolis jury would have a third or more elderly, would be of the 12 that ultimately sit would be 10, 5 white men, 5 white women, 1 mixed race or Asian or Hispanic, and 1 African-American. That would be your typical Minneapolis jury based on its own demographics. This jury is going, so far only has 2 white guys on it, is majority minority so far, or close to it, and has almost no elderly on it. And so it's heavily female, it's heavily young, it's a lot of millennials, a lot of in particular, some Gen Xers, but very few elderly. And more, and then very minority, and at least by demographic polling, that's a convict Chauvin jury. In addition, almost all of these jurors had seen something beforehand, know about the payout by the city, and while they promised to be fair, only 1 or 2 have really said something consistent with innocence for Chauvin. So that's the bad news for Chauvin. The good news for Chauvin is that the court recognized the relevance of the 2019 videotape almost a year to the date prior to Floyd's death, where it's now increasingly clear what really happened, in my view. That what Floyd does is when he gets pulled over, if he has contraband on him, he tries to buy time. And so he starts saying, oh, I'm worried about my mom. I think you're going to shoot me. I think you're going to do something bad. And he's learned that this is an effective tactic to deter police. And while they're doing that, he's either trying to get rid of evidence, drop it outside of the car, dump it someplace inside the car they can't find, or most problematically in this case, consume and ingest any drugs he has on him. So, normally you try to dump drugs down the toilet, but there's no toilet when you're in the car. And apparently his idea was to take them. That means you have sudden, massive ingestion of highly lethal drugs with someone who has a weak heart, according to his health condition. So badly, and what's coming in now is how he reacted initially, not the stuff about crying for his mother and the rest, but what is coming in is when he gets pulled over, he buys time and he tries to ingest drugs. And that he previously was hospitalized just a year before and almost died for doing the exact same thing that they believe he did in 2020. And what that does is that does 2 things. It takes the white hat off of Floyd from a sort of, I always say a lot of trials are about somebody's got to have the white hat, somebody's got to have a black hat. Thomas Mesereau was brilliant at this in winning the Michael Jackson case, but also many other cases. He found some government witness to put the black hat on or some other witness to put the black hat on, so the jury blamed them more than the defendant. Here, Floyd can't really quite easily wear the white hat, but the biggest thing is that it may have been purely coincidental that Chauvin did the knee restraint. It may have had nothing to do with the death because of the sudden, not just ingestion of drugs, which the toxicology report showed, but the sudden ingestion of drugs, and that he'd done it before is going to be the kind of, will be shocking probably to the jury who's likely never heard of this.
I mean, it's an amazing thing because we did talk about this with Robert Gruler last week in our stream with R&R, but we've seen anybody who's seen movies where people do this. They either ingest them with the objective of expelling them, or they put them up the other end with the objective of expelling them to get it over borders or whatever. And occasionally what happens is the bags break and you get, there's a word for it, it's intoxication shock or something along those lines, where, if that is going to be evidence that's going to be adduced, let alone the fact that I think most people don't know that that's what happened this time around. I did not know about that until well into it. Whether or not that changes my initial impression, I would have to be stubborn not to reconsider new evidence, because I did think what I saw Chauvin doing was unjustifiable for a number of reasons. Now, to learn this new evidence is one thing, and then to learn that it was an MO is going to be another. The argument's going to be, like we mentioned last week, sure, he did it in the past, but didn't die from it in the past. So what was different this time around? Was it the need of the neck? But the flip side is, if you ingest it, and if it's not even being ingested in a sealed capsule type thing that is susceptible of expulsion, then you get an automatic absorption, like with Jello shooters, where it hits you at one time. The flip argument is going to be that some experts were saying that habitual users would be used to certain levels that would otherwise be fatal for non-habitual users. How is a jury going to appreciate that? It's going to be interesting, but gosh darn, is this a bit different of a narrative than that which was initially sold?
Radically so. And they found in the back of the police car the evidence of him getting rid of. Like, there's this photo of him having a pill in his mouth, and the question is what that was. Well, they found residue of that pill in the back of the car, which they didn't properly search initially. That is, I believe, fentanyl. So that suggests that's exactly what that was, and that means he ingested a lethal amount of drugs. And I think I think if you're Chauvin, it allows the jury to acquit without them saying what he did was okay. You can say what he did was wrong. The way he handled the restraint under the circumstances was wrong, but it didn't cause the death.
Are they not even going to lose the argument that his method of restraint was wrong because it was, from what seems to be accepted fact, Minneapolis protocol?
Yeah, except for how long it was. That's the hurdle there, is that he was on his neck about 8.5 minutes. And while there is case law that said 15 minutes is okay, the protocol was if they're no longer resisting, you're supposed to flip them over. I think that's his biggest hurdle and just coming in with a jury pool that's preordained against him. They claim they're for the presumption of innocence, but big doubt. It will be interesting because if they lose this case, they're not going to have much excuse, because they'll have the most racially diverse jury maybe in the history of Minneapolis. So they won't be able to say white people caused the acquittal.
No, it'll default into the standard argument of race traitor or whatever, misinformed or whatever. They'll flip the insults. It's just a matter of who it has to fit based on what was done. That's another interesting thing, is where some people might perceive an all-white jury to be pro-acquittal and not pro-conviction. I'm looking at this, not necessarily looking at a disproportionately diverse jury pool as being pro-condemning. We've seen a tendency sort of shift in general, that it's not, you can't really pick these things on certain issues. I think age, and if there's any social media footprint, you can know definitively. But a diverse jury pool, I think, is maybe more optimistic in the sense of objectivity. I don't think it goes one way or the other. But if the prosecution is hoping it goes pro-conviction, I think they might be in for a surprise.
Yeah, I think so. I think the polling in general says that they have a very favorable jury pool. However, in the Minneapolis context, I'm not sure that that assumption will turn out correct. They have, as we talked about from the beginning, a certain group of African-American jurors may actually be more skeptical of Floyd, and because of their experience as both the victims of crime and the victims of police. So I think that will be an X factor. Now, I think there's several jurors that are clearly pro-conviction on there, whereas there's no pro-acquittal jurors, and some of the leaders look like they're conviction. But this would be the kind of hurdle that may be tough for them to overcome. They're going to have to be so biased that they ignore. In other words, the way I look at it is this way: given this evidence is now being introduced, can they come to a conviction beyond a reasonable doubt that it was Chauvin's restraint that killed him? I don't see that personally.
No, it is. I think the determinate fact that will change even the most biased or ignorant in the truest non-judgmental sense, someone who knows nothing about it, the need of the neck and what we all saw in the days following is one thing. To learn that there was ingestion of a lot of potentially fatal drug, that fact alone can change everyone's perspective. And I think, then and not in terms of acquittal, because I may still stick to my original impression, adapted with the new facts, but beyond a reasonable doubt. But for that fact, the beyond a reasonable doubt is much, much different than knowing in the minutes leading up to this, he ingested what would otherwise be a fatal dose of fentanyl for normal people. Then there's a reasonable doubt as to what the determinate factor was. And you get into the issue of what could be a lesser charge that they can convict of if they don't convict on the main 3 charges.
None, because all of them are, they haven't charged them with assault. They could have. Assault is the underlying felony for the felony murder charge. But the problem is they have to get over, they could have chosen a different path. They chose to go just murder. 3 different categories of murder, which somehow are all blending together in this case, which again, I think the top 2 charges don't meet scrutiny under the statute of the Constitution, but Minnesota Supreme Court may wait to rule on that for a couple of years after the verdict in hoping maybe they never have to. But but putting that aside, they chose to go straight murder. I mean, they could have gone with assault. They could have gone with other conduct. They chose not to. And it's because they made it an all or nothing verdict choice for the jury. Their only choices is which category of intent was placed here. Well, was he out to commit a felony? Was he out to endanger lives all around him? Was he out just to hurt this individual recklessly? That's the only standards they have. But for all of them, they have to have causation. And what you may have is someone who abused his police power in a way that did not cause any death. Now, their argument is that everything he did was consistent with protocol. I think that the latter part of the restraint was not consistent with even Minneapolis's police protocol. However, what I don't think is that he thought he was causing a substantial risk of death. Everybody's watching him. Everybody's photographing him. Everybody's filming him. And he's going to commit a murder right there for everybody to watch and witness and videotape. That part I never bought. I thought he was a cop who was used to abusing his power and his history of complaints, which, by the way, are not coming in.
And incidentally, from the beginning, you said, one of the theories was to explain the initial impression, how it looked like he could commit this so brazenly. There was hypothesizing as to whether or not they knew each other, had any sort of animus. And I brought up someone's chat that said Crowder aired the full video. I saw the full video. I mean, it was a long time ago, I think. And I think I saw the whole video. You never know these days. Yeah, but so was there any animus? And apparently, according to one super chat, there was no animus.
Apparently, if there is, I haven't heard the evidence yet because there's been no discussion of it in the pretrial proceedings.
So that's fascinating evidentiary issues. And so the jury's going to hear things that they probably have not yet heard. We'll see if it changes anything. When is jury selection supposed to be over, and when is the substantive airing of the trial supposed to start?
They go back to jury selection on Monday. There's only one juror left for them to pick. Presumably they will. And then trial starts next Monday, the 29th.
Okay, and it is being aired live. Is it going to be online? Is it going to be where's it going to be aired?
It's going to be live streamed by Court TV, but it's accessible to anybody. In fact, people can, unlike some other areas, this areas where you can actually live stream it and comment on it while it's happening because there's no copyright control over what's being broadcast, to my knowledge.
Well, for everyone, double check first. We will double check first, but do not rely on us because I think it was Sullivan's case. You couldn't rebroadcast it, and if you did, you risk being held in contempt.
And that was just the federal court proceedings. And the media access may get restricted if they continue to break the rules. They have been trying to use their cameras to spy on what's on the defendants, like what the defendants are writing in the notes. The defense lawyer is saying.
I was going to say they don't need media there if they live stream it. So media can watch from home and not risk being the snakes that they are in terms of trying to get information that is not necessarily public information. Oh, we got to hear Randy King says Dershowitz stated the judge is mandated to dismiss charges.
Well, I mean, he believes that he has a different opinion. The judge did originally dismiss the one, but the Court of Appeals reinstated it. So that's why it's going to go up to the Supreme Court. I mean, only the Minnesota Supreme Court can reverse what's been done so